Minnesota v. Dickerson, Supreme Court, 1993. Justice White delivered the opinion of the court. In this case, we consider whether the Fourth Amendment permits the seizure of contraband detected through a police officer's sense of touch during protective pat-down search. 1. On the evening of November 9, 1989, two Minneapolis police officers were patrolling an area on the city's north side in a marked squad car. At about 8:15 p.m., one of the officers observed respondent leaving a 12-unit apartment building on Morgan Avenue North. The officer, having previously responded to complaints of drug sales in the building's hallways and having executed several search warrants on the premises, considered the building to be a notorious crack house. According to testimony credited by the trial court, respondent began walking toward the police, but upon spotting the squad car and making eye contact with one of the officers, abruptly halted and began walking in the opposite direction. His suspicion aroused, this officer watched as respondent turned and entered an alley on the other side of the apartment building. Based upon respondent's seemingly evasive actions and the fact that he had just left a building known for cocaine traffic, the officers decided to stop respondent and investigate further. Officers pulled their squad car into the alley and ordered respondent to stop and submit to a pat-down search. The search revealed no weapons, but the officer conducting the search did take an interest in a small lump in the respondent's nylon jacket. The officer later testified, "As I pat-searched the front of his body, I felt a small lump, in the front pocket. I examined it with my fingers, and it slid, and it felt to be a lump of crack cocaine in cellophane." The officer then reached into the respondent's pocket and retrieved a small plastic bag containing 1/5 of 1 gram of crack cocaine. Respondent was arrested and charged in Hennepin County District Court with possession of a controlled substance. Before trial, respondent moved to suppress the cocaine. The trial court first concluded that the officers were justified under Terry v. Ohio. Footnote. Terry v. Ohio is discussed in Section G of this chapter and authorizes the police to stop and frisk, blah, 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 blah. Okay. The trial court first concluded that the officers were justified under Terry v. Ohio in stopping respondent to investigate whether he might be engaged in criminal activity. The court further found that the officers were justified in frisking respondent to ensure that he was not carrying a weapon. Finally, analogizing to the plain view doctrine under which officers may make a warrantless seizure of contraband found in plain view during a lawful search for other items, the trial court found that the officer's seizure of the cocaine did not violate the Fourth Amendment. His suppression motion having failed, respondent proceeded to trial and was found guilty. On appeal, the Minnesota Court of Appeals reversed. The court concluded, however, that the officers had overstepped the bounds allowed by seizing the cocaine. In doing so, the Court of Appeals declined to adopt the plain feel exception to the warrant requirement. The Minnesota Supreme Court affirmed. The question presented today is whether police officers may seize non-threatening contraband detected during a protective pat-down search. We think the answer is clearly that they may. We have already held that police officers, at least under certain circumstances, may seize contraband detected during the lawful execution of a search. Under the plain view doctrine, if police are lawfully in a position from which they view an object, if its incriminating character is immediately apparent, and if the officer had lawful right of access to the object, they may seize it without a warrant. We think that this doctrine has an obvious application by analogy to cases in which an officer discovers contraband through the sense of touch during an otherwise lawful search. The rationale of the plain view doctrine is that if contraband is left in the open and is observed by a police officer from a lawful vantage point, there has been no invasion of a legitimate expectation of privacy, and thus no search within the meaning of the Fourth Amendment, or at least no search independent of the initial intrusion that gave the officers their vantage point. The warrantless seizure of contraband that presents itself in this manner is deemed justified by the realization that The warrantless seizure of contraband that presents itself in this manner is deemed justified by the realization that resort to neutral magistrate under such circumstances would often be impracticable and would do little to promote the objectives of the Fourth Amendment. The same can be said of tactile discoveries of contraband. If a police officer lawfully pats down a suspect's outer clothing and feels an object whose contour or mass makes its identity immediately apparent, there has been no invasion of the suspect's privacy beyond that already authorized by the officer's search for weapons. If the object is contraband, its warrantless seizure would be justified by the same practical considerations that adhere in the plain view context. It remains to apply these principles to the facts of this case. Respondent has not challenged the finding made by the trial court and affirmed by both the Court of Appeals and the state Supreme Court that the police were justified under Terry in stopping him and frisking him for weapons. Thus, the dispositive question before this court is whether the officer who conducted this search was acting within the lawful bounds at the time he gained probable cause to believe that the lump in respondent's jacket was contraband. Under the state Supreme Court's interpretation of the record before it, it is clear that the court was correct in holding that the police officer in this case overstepped the bounds of the strictly circumscribed search for weapons allowed under Terry, where, as here, an officer is executing a valid search for one item, seizes a different item. This court rightly has been sensitive to the danger that officers will enlarge a specific authorization furnished by a warrant or an exigency into the equivalent of a general warrant to rummage and seize at will. Here, the officers continued exploration of respondent's pocket after having concluded that it contained no weapon was unrelated to the sole justification of the search under Terry, the protection of the police officer and others nearby. It therefore amounted to the sort of evidentiary search that Terry expressly refused to authorize and that we have condemned in subsequent cases.